These are case numbers 24-3329 SM and 25-3695 FY. Appearances counsel.
Please go on for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Morris.
Well, we're here for pretrial and PCC. We're also here. Sorry, is it a PCC?
Yeah.
We're also here because Mr. Harrison, last time we were here, you weren't sure whether or not you were going to request the independent evaluation.
I believe that I can make that decision today, and I will formally inform the court that we intend to do so.
To seek an independent evaluation?
We do. I'm having some trouble communicating with Mr. Morris, and I acknowledge it may be me. It may be that I just don't know him well enough yet, but I want to be sure.
All right. How much have you spoken with anybody on that yet?
I have not, Your Honor, under the circumstances. I apologize. If we could have a month, I would be able to. I don't think it'll take that long.
My next question is on the record, this is still Ms. Fioravento's case. So are you handling it just for her today, or is it being reassigned?
I'm sorry, I keep cutting you off.
That's fine.
As far as I know, it's just for today.
All right. All right, what I'm going to do is we don't lose track of this case, we're going to set it for a status conference then. Let's set it for the 24th. 24th?
February.
Yeah. Is there anything else for the record, counsel?
I have nothing further. Thank you, Your Honor.
Court next calls the people of the state of Michigan versus Christopher Antonio Cavazos. This is case number 26-219-FY. Appearances counsel.
I'm Jeff Harrison. I'm here on behalf of Mr. Cavazos.
Joanna Carey for the people.
And we're here for a probable cause conference. I don't believe there's a resolution, but I see, Mr. Harrison, you have a waiver there.
There is not, and that was the question that Chris and I had in the back. We didn't get a chance to fully resolve our plan. Let me give the court some background. There is he has another case, similar allegations, different victim. It's already in circuit court. Strategically, it might make sense to have both of these cases in circuit court. That's all we're trying to get through at this juncture.
Okay.
That's what we found. We're executing the paperwork right now. Yeah, go ahead. Your Honor, I'm presenting the court with a signed bind over, if I may approach.
I have signed that waiver.
Yeah, no.
All right. Court next calls the people of the state of Michigan versus Max Walker Allen.
Okay, I'll come see you.
This is case number 26338 SD. We're here for an arraignment. Mr. Fable, you met or communicated with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes, Your Honor.
And did you also have the opportunity to meet with somebody from the Defender's Office today?
Yes, Your Honor.
I have a complaint that alleges that on or about February 2nd, 2026 in Clam Lake Township of Wexford County, it is alleged in count number 1 that you committed the offense of operating a motor vehicle while intoxicated. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $100 to $500 and or 360 hours of community service, rehabilitative programs. Vehicle immobilization is mandatory with a prior, and reimbursements for the cost of prosecution and governmental expenses. Do you understand those charges and the potential penalties?
I do understand.
Did you read and sign this advice to rights form?
Yes, Your Honor.
Did you understand those rights? You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
Plan to hire an attorney, Your Honor.
Do you have the financial means to do so?
Yes, Your Honor.
All right. The court will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I do not show any prior history for Mr. Fable, and he scores a 0 on the praxis risk assessment. Mr. Hartel, I know he's indicated he's going to hire an attorney, but do you have any comment regarding bond?
Yes, Your Honor, only positive things. The court did note he scores a 0, it's the history, it's been to the moral support. They've already posted a relatively modest, but still a monetary bond. He obviously respects the court enough to come properly dressed, something we don't always see. I would ask the court just to continue the bond he's already posted. Based on the allegations, as I've heard them, I believe random testing would be sufficient. I don't think we need to do daily testing in this case.
All right, thank you. Ms. Dahl?
Your Honor, how much was the bond that was already posted?
It was $250.
Your Honor, the people don't oppose him remaining on the bond he's already posted, but I would ask for random on-call testing. The PBT came back at 0.153.
Was this bad driving? Was there an accident?
He was on the side of the road unresponsive and EMS was called out eventually.
Okay.
The OWI investigation.
All right, given the defendant's lack of criminal history, I will continue the bond as previously set with the following conditions. Mr. Fable, you are to appear as ordered, to keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also ordering that you not consume any alcohol, and you'll be subject to random testings. For right now, I'm going to order no illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for that as well. I'm also ordering that you enroll in community corrections services. Now, because you're going to hire an attorney, you're going to get your next court date at the window when you leave here. Make sure you keep track of that court date and then make sure your attorney gets that court date. Because until they actually file an appearance with the court, they're not going to receive any communication from us, okay? Do you have any questions about your bond conditions? All right, so go out to the front window where you checked in, get that next court date, and then you'll go downstairs to community corrections and get signed up for your testing.
Okay.
Okay? All right, thank you. All right, this is the case of the people of the state of Michigan versus Robert Donald Nelson Jr., case number 253605 FY. Appearances, counsel?
Please sit all for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Nelson, who's joining me at the table.
And we are set for a preliminary examination. However, I do note that Ms. Fiorvento is Mr. Nelson's attorney, and I know she's had some family issues and isn't here today. Mr. Harrison, how are we going to proceed?
It's my understanding that Mr. Nelson would prefer to proceed with Ms. Ferviento.
All right.
It's also my understanding that stipulation was circulated, and I don't know what happened to it.
Yes, Your Honor, I can elaborate on that. If the court would.
Sure.
Your Honor, one of my officers, the one that did the true narc is unavailable. And I requested a stipend order to adjourn, but I believe the defendant did not want to adjourn. And I was going to ask for a motion to adjourn anyway today to next week. It looks like both officers that I would need next week are available.
All right.
Perhaps that's a more expedient way to resolve the issue that.
And I believe we're still within the 21 days.
All right, the court will go ahead and grant the requests. I do find good cause on both grounds. One, that the defendant's appointed attorney is not available today, and also that the necessary witnesses for the prosecution are not available. So we will adjourn today's preliminary examination. We'll get it reset for next week. Anything else for the record, counsel?
No, Your Honor.
Okay. Okay. That's what I got. Trying
Anything else, Mr. Harrison?
to squirrel.
Yeah.
Okay.
Oh, yeah, yeah. Right.
Anything else, Mr. Harrison?
Nothing further, Your Honor. I'm
All right.
sorry.
Thank you.
I thought we had concluded the record. My apologies.
You can go with bailiff. Thank you.
Thank you, Your Honor.
Court next calls the people of the state of Michigan versus Laura Ann Squire. This is case number 26-147 FD, appearances counsel.
Please go for the people.
And I'm Jeff Harrison. I'm here on behalf of Laura. She's joined me at the table.
All right, you may be seated. We are here for a preliminary examination, but Mr. Harrison indicated there was a plan for a plea.
There is indeed. I circulated the substance use assessment to your staff. And I resent it to Mrs. Dell today. So does everybody have that?
I do have it.
Okay. Yes, go ahead, Lisa, I'm sorry.
Your Honor, the people are offering that if defendant were to plead to OWI second offense, the people would dismiss OWI third habitual second.
That's my understanding as well, Your Honor.
All right, give me just a moment. Ms. Squire, have you heard what the attorneys have said the resolution of this case is?
Yes, I am.
And is that how you wish to resolve it?
Yes,
Will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
yes,
It's my understanding that you will be pleading guilty to an added count of operating while intoxicated as a second offender. That is a misdemeanor punishable by up to 1 year in jail, but with a mandatory 5 days jail sentence. Do you understand that?
yes, I do.
Additionally, it could have fines, excuse me, fines of $200 to $1,000. And it does require vehicle mobilization for 90 to 180 days. Do you understand that?
Yes, I do.
In exchange for that plea, the people will be dismissing the operating while intoxicated third offense. That is a 5-year felony and or a felony up to 5 years and or a fine of $500 to $5,000. They'll also be dismissing habitual second offender notice. Is that your full understanding of the plea agreement?
Yes, it is, Your Honor.
Back on January 13th of this year, were you on probation or parole?
No,
Were you on bond?
no,
Do you understand that you have the right to have a jury trial and the right to have witnesses called for your defense at trial, the right to cross-examine all witnesses called against you, the right to testify on your own behalf, or the right not to testify and not to have that silence used against you? You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand all those rights?
Yes, I do.
Most importantly, do you understand that you have that right to a jury trial and that by entering a guilty plea today, you'll be giving up that trial and you'll be giving up that right and you won't have a trial of any kind?
Yes, I do.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No,
Has anybody threatened you in any way?
no,
And is it your own free choice to plea today?
yes,
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
I am likewise unaware.
Then, Ms. Squire, to the allegation that on or about January 13th, 2026 in Boone Township of Wexford County, how do you plead to operating while intoxicated as a second offender?
guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on the 13th of January, were you operating a motor vehicle in Boone Township?
Yes, I was.
And prior to operating that vehicle, had you consumed alcohol?
Yes, I did.
And did you have some sort of police interaction?
Yes, I did.
Did you get stopped or have an accident or something?
It. Black ice
Okay,
and then.
you were driving your husband's new vehicle?
Yes.
All right, I remember that from the assessment. All right. Ms. Dell, were there chemical tests to support the plea?
Yes, Your
There's a
Honor.
lab at 0.165. We would so stipulate.
And Ms. Squire, is it also true that, let's see, on or about November 21st, 2001, in the 86th District Court in Grand Traverse County, you were convicted of operating while intoxicated as a second offender?
Yes,
Do counsel believe the defendant has provided a factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
I do as well.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Squire, I find you guilty of operating under the influence as a second offender. And pursuant to the plea agreement, the operating while intoxicated, I'm sorry, I find you guilty of operating while intoxicated as a second offender. Pursuant to the plea agreement, the operating while intoxicated as a third offender and the habitual second will be dismissed. I know I've seen the assessment. Ms. Dahl, have you seen it as well?
I have, Your Honor.
Do either party have any additions or corrections to it?
Your Honor, I just want to note that her recollection of how much she drank is incredibly inconsistent with the blood results and the PBT result at the scene. She states she had one drink, a small box of liquor, and her blood results show somebody who would have drank at least a bottle of wine instead of a small container of liquor.
Well, we'll just, the court will have inserted in here that the lab results came back at a 0.165.
Yeah,
Thank you.
that's appropriate.
Any elocution, Mr. Harrison?
Well, I think I can address a couple of points that are obviously caught the court's attention. We've since come to realize, we've done a little bit of research, that the particular concoction that she bought, although it was about the size of a can of soda, was a cardboard box, if you will, with a beverage in it, is the equivalent of 3 cocktails of 12% booze. So she did drink substantially more than she realized and more than she should have before she operated the vehicle. With regard to the word escapes me for some unknown reason. The vehicle itself, just for the record, that car is no longer drivable. It was totaled. They're currently battling with the insurance company to see if they're going to get any money back on a 20-year-old $60,000 car that was wrecked as a result of the accident that she was in that night. As well, Your Honor, she is aware that there is a mandatory minimum jail sentence. It's something that she and I talked about. We would ask that pursuant to the statute, 48 hours be served and that she be allowed to do that on the weekend. Now, the reason I'm asking for that accommodation is she runs a business during the week. And if for no other reason than the statute appears to accommodate that sort of request under these circumstances. Normally you'd have an OUI third in front of you pleading to a second, and I think in the back of the court's mind, at least that's my perception of it, and I don't have any negative reaction to that. The court's thinking, it's your third one. You didn't learn anything the other two times. What the heck's wrong with you? In this case, though, I would, just for the record, you've already noted the second offense was in 2001. The first offense was in 1996. So it is 3 over a lifetime. In this case, 30 years of time have elapsed between the first and the third. Does that excuse her behavior that night? No, it doesn't. But it does show us that this is not a chronic situation. Once, I suppose, this is something that could happen to anybody unless they don't drink at all and drive. She consumed much more alcohol than she realized and got into a situation with weather conditions where she lost control of the vehicle. She was actually pinned upside down in the vehicle and had to be pulled out of there by a passerby. So this was no small incident, and this was no small impact on Laura Squire, the way that she approaches or is going to approach these situations in the future. She may not have noted in the report, although she did speak with some degree of candor with the assessor, but she knew she wasn't supposed to be driving that particular vehicle either. So this has had a number of impacts on her that might not be apparent from the surface as a result of this one incident. She betrayed the trust of her husband. He has forgiven her for that, but that's an issue that never really, it's going to take a while before that goes away entirely. She deprived her family of a substantial asset, and she did a really dumb thing for selfish reasons because she felt like she needed to go out and pick up some jewelry that had been repaired, etc., and run a couple errands. Obviously, she had no anticipation whatsoever that it was going to blossom into the full-fledged debacle that it turned into. But here's where we are. I think I would suggest to the court that the 5 days in jail is going to be more than sufficient. Incarceration, she probably has credit for a day or two now. And as suggested in the substance use assessment, she could benefit as well with reminders, counseling reminders, with reminders that what a dangerous thing it is to drink and drive. I think as time goes by, this will come to be a much more watershed moment in her life, because I can already tell, as far as making future plans, that they're already planning around the fact that she will not be drinking or driving in the future. That's what they're planning to stick to. And it's probably a good idea. Thank you.
Ms. Dole?
This is not an oopsie situation where anything, either one of us could have done this. This is somebody who has 2 prior OWI convictions, who had her license revoked, who decided to take a vehicle against the law, and then to further aggravate the situation, drink and continue driving. She knew better. She caused a rollover accident. Luckily, she was the only one injured and there was only property damage. She could have killed somebody. She has clearly not learned what she is allowed and not allowed to do. I believe her substance use assessment was minimized based on what she said she drank. The fact that she had previously been counseled on alcohol use, has gone to AA meetings, and still decided to drink and drive, neither one of which she should have been doing, let alone in a combination. In this case, considering the circumstances, the damage that was done, and the fact that she continued to drive while revoked and then drank and drove, I would ask the court to sentence her to 20 days jail. We are not opposed to having that served on the weekend, so she may maintain her employment. I would ask the court to sentence her to probation for at least a year. It's clear she needs further counseling and further education on alcohol use. To make sure that this never happens again. She had all of the restrictions of not driving placed upon her already, and that still didn't keep her from driving. So I would ask the court to impose those sanctions in addition to blood draw reimbursement to the sheriff's department and reimbursement to the prosecution.
So she was suspended at the time that this happened?
I believe she was revoked,
She was revoked.
and she can clarify that.
Well, counsel, a couple of red flags have come up for the court, and I'm going to adjourn the sentencing. I want another substance use assessment done with the actual blood result given to Catholic Human Services, because I question whether or not they had enough information to make an actual determination as to her, what disorder she may have. I think it should probably also be known to them that she was driving on a suspended license, and what she was actually, and that the drink that she had consumed had, as Mr. Harrison says, the equivalent of 3 cocktails, I believe it is.
That's right.
So I don't believe that the assessment, at least, I question whether it's accurate based on the missing information. So I am going to adjourn today's sentencing, reorder an assessment, and we'll be back here in a couple of weeks.
Okay, thank you.
Ms. Squire, just a reminder that your bond conditions continue. You can go out to the front window where you check in and get your next court date. All right, thank you. And yes,
Just a question, does Catholic Human Services normally get a copy of the police report as part of
They
their
don't.
assessment?
they don't. It's usually all self-report.
Is that something that might be helpful in this circumstance?
I'm not going to step on their toes as to how they operate, but
Somewhat in her defense, Your Honor, she had not received a copy of the police report until today. So some of the details she may not have purposely fudged, but be that as it
well,
may.
I'm not accusing her of fudging
Okay.
anything. I just want to make sure that Catholic Human, because there's some gaps in here that Catholic Human Services didn't have. So that's why I'm doing that. I don't take it that I distrust you. It's just, I need some more information. So,
Thank you.
okay, you can go out to the front window, and the council, we're here for a probable cause conference. There is also a bench warrant for a positive test. And then the defendant tested positive today. So first of all, we'll do the arraignment on the bench warrant. Mr. Nicholson, it's alleged that you had a positive test for benzodiazepine on February 1st, and that you also appeared for testing after hours. You have the right to have a contested bond violation, in which the prosecutor would have to prove to the court that you did in fact violate your bond conditions by testing positive and appearing after testing hours, or you could admit responsibility. Mr. Harrison, how did your client wish to proceed with the violation?
We wish to proceed with a more formal hearing. We believe it to be a false positive, but we're going to work on researching that.
All right, the court will set it for a contested hearing. The court on its own will add today's violation, or alleged violation, and that is that he tested positive for benzos again today, with a second follow-up test having been given as well. And we're also here for a probable cause conference, and it looks like there's not a resolution. Am I correct on that?
There is not, and as a added element, we do seek to waive the 21 days. That's primarily, unfortunately, due to the fact that I'm in trial. The following week, February 10, And right now, I can't promise I'm gonna have sufficient manpower to cover that.
I understand. So the court is aware that following week, or sorry, the parties are aware that following week, we are having a visiting judge for prelims. So we will set this then,
For the week of the 17th.
week of the 17th. Yeah.
Okay.
So that brings us what to do with bond, Mr. Harrison?
Well, Your Honor, we're taken aback by the results of these tests because Mr. Nicholson has never knowingly taken a benzodiazepine. So it came as news to him, especially today's test being positive as well. That's why we're convinced that it, perhaps a more thorough lab analysis will reveal that it is in fact a false positive, but that we're really at a loss to explain that. I mean, I don't know how to say this the right way, so I'll just say it. Mr. Nicholson is well aware of chemical compounds and their effects on the human body. And he has taken great pains to stay at least clear of anything that would involve his bond. In this matter, as the court is aware, it's a substantial charge that conceivably carries a lot of potential long prison term. In addition, he has extended resources to post his bond in this case and would never do anything consciously to impugn that as well. So I would like an opportunity to at least try and explain this to the court's satisfaction.
Thank you, Ms. Carey.
I don't have his criminal history in front of me. But I think, given the second subsequent and habitual offender court, I would venture to say that it's extensive. We have a person that we strongly believe is distributing methamphetamine or selling it in our community on at least two occasions that he's charged with, and likely several more. Given the circumstances, testing positive, and I might have bought it if he had tested positive one time, but now we have him testing positive twice. So I would ask the court to consider that and consider the remand. Thank you.
Thank you. In the defendant's past, there's an operating while intoxicated from 14, the use of a narcotic in 16. In 18, there was a delivery on school property, possession on school property, possession of meth on school property in a drug house. There's also several MIPs from 99 through 2000. He was just off parole 23 for a delivery of methamphetamine. The court set bond at $25,000 cash surety. Defendant did not appear last week when we were originally set. His bonds person had to bring him in. And then since then, we've had two positive, allegedly, well, I guess 4 tests, because there was the one test and then a follow-up and then another test today and a follow-up, all testing positive for benzos. The court will remand the defendant to the custody of the jail until we have a hearing. However, I am not forfeiting bond yet.
Thank you, Your Honor, for that consideration.
Anything else for the record, counsel?
No, no,
Court next calls the people of the state of Michigan versus Skylar Jade Hall, case number 26217 FY. And we are appearances counsel.
Joanna Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Skylar. She's joined me at the table.
And we are here for a probable cause conference. Does not look like there's a resolution. Is that correct?
There is no resolution. That is correct, Your Honor. I'm sorry.
And
Reconstructed your sentence.
Mr. Harrison, you're waiving the 21 days.
Yes, we are, again, for similar scheduling purposes.
So that puts us out to the 17th. Ms. Carey, are you aware of anything that would hang up a prelim that day? Mr. Harrison?
I am not right now. I should be available as far as that goes.
All right, we will set this for a preliminary examination on the 17th. Ms. Hall, just a reminder that your bond conditions continue. And you can go out to the front window where you checked in to get your next court date. Before you leave though, counsel, is there anything else for the record?
There is an issue that we would like to address. And I realize this is a gray area. It's getting into bond conditions. So I would ask if Mrs. Carey is willing to waive notice for such a. Well, she's currently being randomly tested and the testing hours are between 8:30 and sometime in the afternoon. But if her number were to be called, she starts work at 7. She's a probationary employee of Piranha Hose and would not be at liberty to simply leave and perform the testing because of that 8:30 office hour, whatever it is, for community correction. The problem that I have, or the concern that I have, is that I don't know what the alternative would be except to eliminate the testing requirement or limit it to at the request of community corrections or something like that. I'm aware that their protocol, the numbers called, you're expected to get there. And for her to call in every day and say, I can be there after 3 may not be sufficient to avoid what I would view to be an unnecessary violation or allegation of a bond violation.
What hours? So I know you say she goes in earlier in the morning. When does she get out?
3 o'clock.
Ms. Carey?
Well, Your Honor, I have somebody that's been charged with possession of cocaine and according to the report, admitted she knew the roll of dollar bill, the straw, the baggie, which she believed to be empty, had been in her, was in her vehicle, that she left on the side of the road unattended, which also raises some suspicion when people do that. So I think testing is necessary. I don't know if she can work with the corrections to test in the afternoon, but
Yeah, that's fine.
I think that I'm gonna ask the court not to eliminate that bond requirement.
Mr. Harrison, has your client had any conversations with community corrections about the issue?
She's not, she just brought it to my attention once she learned of their protocol. We did have a meeting yesterday. We're just trying to get out in front of the issue so we don't end up fighting over a bunch of violations.
My understanding is community corrections usually tries to work with people, so I'm going to keep the bond conditions as it is
Okay.
now. She can certainly have that conversation, and if it doesn't work out, we can readdress it.
We appreciate that, Your Honor. I just wanted the court to be fully appraised.
Anything else for the record?
Nothing further, Your Honor.
All right. Now you may go out to the front
Thank
window. Thank you.
Yes, sir. You too.
All right, court calls the people of the state of Michigan versus Eric Joseph St. Ange Jr., case number 2687 FY. Appearances.
For the people?
I'm Jeff Harrison. I'm here on behalf of Eric St. Ange's. Next to me at the table.
And we're here for a probable cause conference, but it looks like there's a resolution. Am I correct in that?
There is indeed.
Ms. Bell?
Yes, Your Honor, the people have offered that if the defendant were to plead to the count 2 domestic violence aggravated, count 1 would be dismissed.
That comports with my understanding of the matter as well.
And are we able to sentence today?
Yes, Your Honor, we did.
Okay.
The victim.
All right. Well, sir, have you heard what the attorneys have said the resolution of this case is?
Yes,
And is that how you wish to resolve it?
yes,
You please raise your right hand as best as you're able. You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
yes,
All right, you may put your hand down. So it's my understanding that you'll be pleading guilty to count number 2 of domestic violence aggravated. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000, and consecutive sentencing may be imposed if it happened in a place of confinement. In exchange for that plea, the people will be dismissing count number 1 of assault with intent to do great bodily harm less than murder or by strangulation. That is a felony punishable by up to 10 years in prison and or a $5,000 fine. Is that your full understanding of the plea agreement?
yes, sir.
Back on September 19th of last year, were you on probation or parole?
No,
Were you on bond?
no, sir.
Excuse me. Do you understand that you have the right to have a jury trial and have witnesses called for your defense at trial, the right to testify or to remain silent and not have that silence used against you, and also the right to be presumed innocent unless proven guilty beyond a reasonable doubt? Do you understand all those rights?
Yes, sir.
Do you also understand that by entering a guilty plea today, you'll be waiving that right to a jury trial and you won't have a trial of any kind?
Yes, sir.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plead?
Yes, sir.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
I am likewise unaware.
Then, sir, to the allegation that on or about September 19th, 2025, in the city of Cadillac of Wexford County, how do you plead to count number 2 of domestic violence aggravated?
Okay.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on the 19th of September between you and Brianna?
We went out drinking at 20. And went back to her house and had a few more drinks. I can't remember exactly what the argument was about, but we started arguing. And when we started arguing, she asked me to leave, which I took as drive home drunk, which I shouldn't have. I could have just walked. And I got physical with her.
What do you mean by that?
Well, I mean, as I smacked her and put hands on Brianna.
So I think I know what you mean by when you say put hands on her, but can you describe that more for me?
I pinned her down on the stairs and slapped her hard enough to make her ear bleed.
When you say her ear bleed, was that like an outside bleed or was it an?
I believe so, on the outside, yes.
Okay. Any other injuries she sustained?
I believe around her neck.
What happened around her neck?
I put a hand around her neck.
So what injuries did she receive?
I believe bruises.
Mr. Harrison, do you have any voir dire? Get us to the aggravated part.
It's my understanding that there has to be demonstration of an injury, and I believe he's testified to that.
What's a serious or aggravated injury?
So the injuries on her neck, were they more than just your standard kind of bruising,
I'm not
as far as
sure.
you know? Okay, and the injury to her ear was sufficient enough to draw blood? Is there any permanent or long lasting?
I don't believe so.
Okay. I'm kind of at an impasse here on it.
Well, based on what I've heard, I don't believe we rise to the level of a serious or aggravated injury. Do the parties want a couple minutes to talk about it?
Your Honor, I mean,
Continue on.
You may.
Good idea. When you said you put your hands on her neck, did you in fact choke her?
Yes.
Okay. Was there a point at which she was having difficulty breathing?
Possibly.
Okay, so from your mind, would that constitute something like more serious than just the usual bruising?
Not-
You're not a doctor, but,
Probably.
okay, so would you agree that she had trouble breathing at one point and asked you to stop? Okay, thank you, Your Honor. I believe that. Sufficient factual basis.
Give me just a moment. Mr. St. Ange, do you know, was there medical treatment provided?
Yes, I believe so.
Do you know for what?
I'm not entirely sure. I was just told that there was.
Counsel, I'm looking at the jury instructions for aggravated assault, 17-6. And a serious or aggravated injury is a physical injury that requires immediate medical treatment or that causes disfigurement, impairment, health, or impairment of a part of the body.
Your Honor, I believe choking somebody to the point where they can't breathe is impairment of their bodily function.
That was my understanding as well, Your Honor. I can.
Did she receive medical treatment for the choking?
Your Honor, she refused medical treatment because she does not have insurance. Just for the record, I believe choking somebody, I'm not a medical doctor, but I believe choking somebody causes a risk of aneurysm, which could lead to death. Choking somebody could also impact the trachea and other parts of
Okay,
the
but
neck.
the problem the court has is that's all could be. This is causes a serious or aggravated injury. And I haven't heard anything that says that we've reached the level of a serious or aggravated injury.
Well,
Um,
Your Honor, I believe the other part was that it impacted bodily function, which it did.
what did it impact?
Her breathing. She was not able to breathe to a time, and I believe the police reports, her statement.
So it's
was-
not bodily function, it's that causes disfigurement, impairment of health, or impairment of a part of the body.
Your Honor, if we could come back for another plea and sentencing, I could try to do some legal research as to this specific issue and whether choking somebody has been found to be an aggravated injury in the past.
All right. Any objection to that, Mr. Harrison?
I have no objection to that.
All right, then we will set this over for another day.
I had not anticipated this issue. I apologize to the court.
Have them tomorrow or looking at
How much time do the parties want?
A week, Your Honor, should be sufficient.
Mr. Harrison?
That'll be fine, Your Honor. My only concern is that I do have a trial next week. And then 2 weeks after that, but we'll get it sorted out.
All right, the parties, if you decide you want to take another run at it, we can certainly get it back on the docket soon.
Thank you, Your Honor.
Anything else for the record, counsel?
Not at this time, Your Honor.
No, Your Honor.
All right. All right, person at the jail, please state your name for the record.
Mason Hawkins.
This is case number 26-216FY, the people of the state of Michigan versus Mason Daniel Hawkins. Mr. Hawkins, you met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes.
And did you have the opportunity to meet with somebody from the defender's office today?
Yes.
I have a complaint that alleges that on or about October 25th, 2025 in Liberty Township and Manton in Wexford County, it is alleged in count number 1 that you committed the offense of assault with a dangerous weapon, in particular a 2007 GMC pickup. That is a felony punishable by up to 4 years in prison and or a fine of $2,000 and DNA to be taken upon arrest. In count number 2, it's alleged, in count number 1 happened in Liberty Township. In count number 2, it looks like that happened in the city of Manton. And that is that you committed the offense of driving reckless. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense. But you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I do plan on hiring an attorney.
Do you have the financial means to hire an attorney?
Yes, I do.
All right. The court will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be bound over to stand trial in circuit court. Do you understand that?
Yes.
Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I do not show any criminal history for Mr. Hawkins, and the praxis scores him at a risk level 2. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor, even though he will be using a private attorney in the long run, I do believe it's appropriate to ask the court to consider a personal recognizance bond. As was noted, he has no adult history. I don't want to go into anything that even mildly might be protected by the attorney-client privilege. But what I will say is I do believe that anything he may have had as a juvenile was completed successfully. He's always been to court. He has strong family ties to the community. And that I realize these are serious allegations, but I believe those concerns can be overcome with non-monetary bond conditions, perhaps no contact order with the alleged victim, perhaps conditions of no threatening or harassing behavior to everyone, no unsafe driving, things of that nature. I'd ask the court to consider that, or at least a low monetary bond, so his family could help him out. If I recall correctly from talking with him, he's still in high school. He wants to get back to class, which is even more ties to the community because he has every desire to graduate on time. I'll phrase it that way. Thank you.
Thank you. Ms. Dole?
Yes, Your Honor. The allegations in this case is that defendant hit his aunt with his vehicle. It was contact between her arm and the side mirror. Additionally, he tried to drive at her again and then swerved last minute to avoid hitting her. So there's potentially 2 felonies assaults, although only one was charged, and reckless driving when it looks like he had a restricted license at the time. So our concerns are is that he, although restricted, was abusing his privileges to drive recklessly and attempt to harm his aunt with the vehicle. Based on those allegations, although this is his first adult potential, this is his first adult case, I still feel that the allegations and the fact that his license was restricted at the time, and the fact that this is family that he is accused of doing this too, I believe a personal regardless bond is not appropriate. We would ask for a monetary bond, no contact with the victim, no contact with her address, where there was an initial reckless driving where it's alleged he went onto her lawn, hit her mailbox, and then drove off. So we're asking for no weapons or firearms, and we ask that well, I don't know if the court can order him not to operate a vehicle, but at this point, I believe it's dangerous for him to operate any vehicle. Thank you, Your Honor.
Ms. Dahl, I note this is alleged to have happened back in October, and it was just sworn to a week or 2 ago. When did your office receive the report?
It's November 10th. We did ask for follow-up interviews. There was a few different witnesses that we wanted to collect. There was an interview with the defendant and some further investigation that contradicted his statements as to what happened. So it took a little bit for follow-up for us to charge.
All right. Mr. Hartel, do you know, was he picked up on the warrant? Did he turn himself in? How do you know how that came about?
That part I don't know, Your Honor.
Mr. Hawkins, Mr. Hartel said that you're still in school. Is that accurate?
Yes, I'm a senior in
attend-
high school right now.
You attend in person?
Yes, I do.
All right. And are you set to graduate in the spring?
Yes, I actually got picked up I was in class when I got picked up for my warrant.
They came to the school and got you?
Yeah,
All right. The court is going to authorize a personal recognizance bond in this case. I believe it's appropriate. With the following conditions: that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you not have any contact with Alexandra Rice. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. You are not to purchase or possess any firearms or weapons, and not act in any threatening, intimidating, or harassing behavior. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
yes, Your Honor.
I am also ordering that you enter in community corrections services. Now, if something happens that you cannot hire an attorney or it doesn't work out, you can always request that the court make a referral to appoint an attorney. And if you decide
Okay.
that you want to do that, you'll need to contact the court and we'll send you the paperwork to make that happen. Also, because you haven't hired an attorney yet, you're going to have to keep track of your next court date and make sure your attorney gets that, because until they actually file an appearance with the court, they're not going to receive any communication from the court. And you should have that next court date before you leave the jail today. All right.
Okay.
So when you're released today, you'll need to come over here to community corrections at the courthouse and get signed up for those services. Okay.
Okay.
Yes.
Will there be a no contact with the address of Alexandra Rice?
Yes. What is that address?
6236 43 Road in Manton, Michigan.
6236.
Correct.
All right. I'm also ordering no contact with that address. Okay. All right. Thank you, Jail. Next to Raymond. It looks like you currently owe the court $1,361.88. Are you able to pay on any of that today?
Not today.
All right. Then what I'm going to do is I'm going to set you up then for a financial review hearing. Well, let me ask you, are you able to make any type of payment arrangement?
Not today.
Okay. So we will set this up for a financial review hearing in 2 months. And we'll see if things change then. You can go out to the front window where I will also cancel the warrant. You can go out to the front window where you checked in and get that coordinated, okay? All right, thank you. A person at the jail, please state your name for the record.
Tamika Erickson.
This is case number 26339FY, the people of the state of Michigan versus Tamika Unique Erickson. Ms. Erickson, did you have the opportunity to meet with somebody from the defender's office today?
Yes,
Looks like you also spoke with somebody from Community Corrections and gave them some contact information. Was that information accurate?
yes,
I have a complaint that alleges that on or about February 2nd, 2026, in the village of Meesick of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. The prosecution has opted to charge you as a second subsequent offender, meaning that you have at least one prior drug conviction in your past. That makes that 10-year felony a 20-year felony, and the $15,000 up to $30,000. In count number 2, it's alleged that you committed the offense of controlled substances, possession of cocaine or another narcotic in a mixture of less than 25 grams. That is a 4-year felony and or a fine of $25,000. However, they have opted to charge you as well as a second offender in that case, which makes the 4-year felony an 8-year felony and the $25,000 up to $50,000. In count number 3, it's alleged that you committed the offense of controlled substances possession of a narcotic less than 25 grams, in particular fentanyl. Again, that is a 4-year felony and or a fine of $25,000. They've charged you as a second subsequent offender, meaning that that 4-year felony is now punishable by up to 8 years in prison and or a fine of $50,000. In count number 4, it's alleged that you committed the offense of controlled substances maintaining a drug house. That is a high court misdemeanor, punishable by up to 2 years in prison and or a fine of $25,000. They've also charged you as a second subsequent offender in that case, which makes that 2-year high court misdemeanor a 4-year felony and or a fine of $50,000. Do you understand those charges and the potential penalties?
yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request one.
Court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offenses. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to bound over to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. The bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, in 21, I show you failed to display a license. In 23, possession of meth. In 17, looks like there was a couple of 7411s for possession of marijuana. And the practice scores her at a risk level 5. Any comment regarding bond, Mr. Hartzell?
Yes, Your Honor. I would ask the court to amongst other things, consider an immediate release to treatment. I won't go into anything protected by the attorney-client privilege. I know I may or may not be the one firmly assigned to her case, but I am the one speaking on her behalf today. I believe without any of us being medical professionals, the court can take judicial notice that she does not appear to do well. She does have a prior history, as the court did note as well. I would ask the court to consider allowing her to go to treatment. She did express a strong interest in that earlier. I believe it's appropriate just to phrase it that way without going into too much detail, especially the nature of these allegations. She does have strong ties to the community, or at least the Michigan area, at least. I know she's not from our immediate area. She's from Manistee County, but she's lived there for quite a while, has family out there. She does work as a subcontractor doing housekeeping. I forget exactly which resort, but for one of the resorts in the Manistee area, just so the court is aware. But again, she's very interested in immediate release to treatment. And I believe that after completion of treatment, if the court had the usual conditions, if she doesn't complete it, if she has to come back to jail, but if she does, then perhaps even higher than regular testing if the court had concerns due to a prior history. But I do believe non-monetary bond conditions can overcome any of the court's concerns. Thank you.
Thank you. Ms. Dahl?
Your Honor, this is not just a case of an addict who simply possessed or intent for personal use. Her house was used for drug deals. When a search warrant was conducted on the residence, in her bedroom was found 17 grams of crack cocaine, 18 grams of fentanyl/heroin. And there's some allegations that she assisted in bringing somebody to her house in order to sell drugs out of her house. Additionally, drugs were found. She was asked multiple times if she had any drugs on her. She eventually admitted that she had drugs in her, and those tested positive through TrueNarc. So this is not just an addict who needs treatment. This is somebody who is involved in sale of drugs in this community. So I would ask for a high bond to be set based on the danger to the public and her history of drug use. Thank you, Your Honor.
Thank you. Based on what's been presented to the court today, I do find the defendant as a threat to the community. Bond will be set at $75,000 cash surety with the following conditions: that Ms. Erickson appear as ordered, keep her contact information current, not leave the state without permission, and to commit no known crimes. Additionally, not to consume any alcohol, no drugs, including recreational marijuana, and be subject to random testing. I'm sorry? Ms. Dull, my reading of the probable cause affidavit indicates that there was a minor there as well. Do we know, is that a relation or is that somebody else?
I don't know, Your Honor.
All right, I'm also going to order no unsupervised contact with anyone under the age of 16. And if she does bond out, she'll be placed on GPS tether house arrest with community corrections terms. I am not going to grant the bond request for treatment today. However, just because I don't have enough information, Mr. Hartel, your office knows how to file the appropriate motions.
Of course.
That's it from the jail. How about now? Is that better? All right, court calls the people of the state of Michigan versus Michael Davis Haynes. First case is 26-184 FY. Then we have 25-4867 FY. 25-3779 SM. And 25-4866 FY. I believe we are here for probable cause conferences and bond violations for all the files except for 3779 SM. That is a probation violation. Appearances, counsel?
Joanna Carey for the people.
And good morning, Your Honor. For the record, Paul Tlund on behalf of Mr. Haynes, present in the courtroom.
All right, I guess my first question, do we have any resolution to the probable cause conferences today?
Not at this time, Your Honor. I'll be frank, this recent case was a little bit of a monkey wrench in my plan in terms of trying to get to a resolution. I believe that we've gone from like a drug case into a gun case, Your Honor, frankly. Just for clarity's sake, Your Honor, is the SM case, the 25-3779 SM case, is that that's just the misdemeanor charge, and it's separate, it's a separate offense from the 4866 and the 4867 files?
Yeah, and there's only a probation violation on that. It's set for, he was already
Okay. That
pled and sentenced on that. It's just a probation violation.
okay. That was kind of my question. I wasn't sure if it was a probation resolved matter or this was the bond violation itself. Okay, very good. With that in mind, my understanding was that, or at least I was under the impression that there was some perhaps new evidence in the 26184 FY matter. Had there been any supplementals or any other further interviews done with witnesses that may alter the course of that case?
Not that I'm aware of. I know that one person is trying to talk with me, but she was told to contact the police.
Okay. What I guess, Your Honor, if we could just have a week adjournment, I want to get to the bottom of that, if that's inculpatory, exculpatory. And I believe that keeping all these matters together is prudent. Mr. Haynes is accruing some credit as he sits. He's and with a 7-day adjournment, there's no threat to the safety, society, risk of danger, non-appearance. And I could get a grip on if that evidence is relevant, pertinent, helpful at all, and just take it from there.
Ms. Carey, any objection?
No, at some point I'd like to.
I understand. It's my understanding that the probation violation is based on the new criminal behavior, correct?
So it would be helpful, Mr. Thailand, maybe if we had a phone conference.
I was going to suggest that, if you please. I will. I'll get your number from the Journal. I'll call you this afternoon.
Okay.
All right, we will go ahead and we will set this out for one more week. However, I'm unlikely to delay the probation violation or the bond violations beyond that, just so everybody's aware.
Take care.
All right, anything else for the record?
For now, that's it. Mr. Haynes, we'll talk this afternoon as well.
Mr. Haynes, did you hear your attorney? He said that he'll talk, you said this afternoon, correct?
This afternoon, if you can call me.
All right, you can call him this afternoon.
His number's not on the phone where I can call him. It's blocked.
I'll call the jail and orchestrate that phone call, Your Honor.
He'll contact the jail and get that worked out. Okay? All right. All right, thank you.
Thank you, Your Honor. We'll see you the 10th at 10 a.m. I'm sorry, the 10th at 10:30.
Yes.
Thank you so much.
Thank you.
Have a good day.
You too.